Good afternoon, everyone. Thank you for joining us. My name is Ann Bittinger. I'm the owner of the Bittinger Law Firm. Today's webinar is called Uh-oh, Dr. Smith Quit and Opened an Office Next Door. She's Stealing Our Patients. This is the latest in our monthly Uh-oh sessions, in which we provide education on subjects that we get calls about on a frequent basis here at the firm. We try to address issues that are relevant to what we are doing here at the practice. You know, we would find that clients would call us and say, uh-oh, we've got this problem. And so we came up with the name for the Uh-oh series because clients, physicians, company CEOs, or practice administrators would call us and say, this is our big problem, big sigh. Do you have a few minutes to discuss it? And so as we saw trends, we developed the Uh-oh series webinars. I have muted all of your lines, and I ask if you have any questions at the end, feel free to email me. My email address will come up. And with that, let's go ahead and get started. In the world of non-competes, what we deal with typically here at the Bittinger Law Firms are physician non-competes that are tied with their employment agreement. So when we say non-competes, we mean, is there something that when the physician is no longer employed with the company, with the practice, with the hospital, that keeps that physician from working for a certain amount of time in a certain geographic area? Non-competes can apply in all sorts of settings, but we're going to talk about it here, for the most part, in the context of physician employees. So some of the questions that we receive here, you know, are non-competes enforceable? In fact, I had one client who said yesterday, well, non-competes don't hold up in court anyway, right? That's kind of the furthest from the truth if the non-compete language in the contract meets the requirements that we'll talk about here today. I often hear from physician clients, and I should say that here at the Bittinger Law Firm, we represent both the groups when we're writing the non-competes, and we represent individual physicians who are either planning to leave and are concerned about where they can work, or who have already left and received a cease and desist letter saying you can't open your practice there. So we kind of go on both sides. But often, you know, one of the things that the physicians say is, what if I can't earn a living? You know, so are you telling me I have to move to Daytona or Tampa or Atlanta? You know, if this non-compete is enforceable, I can't work here. We'll talk a little bit about that. Not so much from the physician standpoint, but what if patients need or want to see me? Can my former employer really tell Mrs. Smith, who I've been treating for the last 25 years, that she can't come in and see me? We'll talk about that. Physicians often say, well, what if I never signed this non-compete document? Or what if they can't find a written document? Does that make a difference? Another perspective that we have here is, you know, how can I negotiate the terms of my non-compete in my proposed employment agreement? We do represent individual physicians here who have us review their employment agreements prior to joining a practice. And one of the things I often hear is, well, is this non-compete negotiable or not? So we help give some physicians some tools where perhaps there could be a win-win on the non-compete going into a relationship. And then the question at the end of the day for those physicians who come in and say, God, you know, I can't stand it at this practice anymore, I really want to go and start my own, just because I signed a non-compete, will they actually enforce it? So these are some of the things that we see here and that we'll spend the next half an hour or so talking about. Non-compete law is predominantly, if not exclusively, governed by state law. The different states base their laws or their case decisions on either statutes or on common law decisions. Common law would be more like what's right, what's fair from an equitable standpoint in terms of restraint of trade or business or tort, that sort of a thing. here in Florida, and that's what we're going to talk about mostly today, is the Florida situation, we actually have a really strong statute that governs this area. Most states don't have statutes this detailed. So I'm going to do a little bit of walking you straight through the statute, just like how we lawyers would analyze it, and give you some insight into how a judge, if faced with a contract that was a restriction against competition, would analyze the statute too. So we actually have a prohibition against restraints of trade in Florida. Florida is a pretty pro-business state, and our statutes in this area reflect that. Every contract, combination, or conspiracy in restraint of trade or commerce in this state is unlawful. Well, like any good law, there are exceptions. But we go down the statute a little bit further to subsection 33, and it says that contracts in restraint of trade are valid if certain requirements are met. The key three issues that we're going to talk about today are time, area, and line of business. The Florida statutes allows for restraints of trade, which a non-compete is considered a restraint of trade, as long as the restrictive covenant is reasonable in terms of time, area, and line of business. So it's not prohibited as long as the terms are fair. The key to any analysis is whether the employer has what's called a legitimate business interest in keeping the employee from doing what he wants to do. So the person who seeks enforcement of a restrictive covenant has to plead and prove the existence of one or more legitimate business interests. In the 4 bullet points there, those are some of the things that could be considered business interests. You know, if they stole a trade secret and started replicating it, that might be something that would be considered reasonable. But I put in red font the 3rd bullet point here, because this is the one that's really the most litigated now and that we will talk about in the next few minutes. Substantial relationships with specific prospective or existing customers, patients, or clients. What I find interesting in this statute as a healthcare attorney is that obviously this statute is intended to cover everything from salesmen in any industry to executives in Fortune 500 companies, but they actually had the sense and the, I think, direct intent to have this apply to physicians in that they actually use the word patients in the statute. That line there in red is a specific quote from the statute. So in order to enforce a non-compete in the state of Florida, the employer has to show that they have a specific, they have a substantial relationship in specific patients, specific prospective patients or existing patients. And it's that specific prospective one that is getting a little dicey in our court system right now. But basically, to recap, if a physician group, a hospital, a health system, an employer has relationships with existing patients, then they have a legitimate business interest that they can enforce against the employee. So this is a really, really strong pro-employer statute as to this. This really says that if a judge is looking at a non-compete and the employer can show that we have a specific relationship with these patients. Here's our patient list, Your Honor. He has seen 50 of these 500 patients in the last 2 months. That judge is going to uphold that as a legitimate business interest, subject to the caveat that the time and the place have to be reasonable. So I have in bold here at the bottom of this slide another term from the statute, and that is that any restrictive covenant not supported by a legitimate business interest is unlawful and is void and unenforceable. So let's look at how the non-compete elements work together, those 3 elements that I keyed up for you. First, we have time. By time, we mean how many years after employment does it cover. The second element is area. meaning geographic area. The third element is the line of business, the type of medicine or the type of activity. So we have time, area, and line that go together. One of the questions I had at the beginning slide was, well, what if I never signed anything? In the Florida statutes, it is required that any restriction on trade be signed by the person against whom enforcement is sought. So if you are a physician practice leader or administrator and you have not done a nice inventory to make sure that you have fully executed agreements for all of your physicians, I can tell you that you might be walking on some soft land if you don't in terms of enforcing the non-compete. So some of these little housekeeping things like, yeah, we actually did get that signed contract back from Dr. Smith can really, really, really make a difference, because if Dr. Smith leaves, opens up a practice across the street, but you never got a signed employment agreement back from her that had her non-compete in it, sorry, no non-compete. I'd like to take just a moment to talk about burdens of proof. We are going to talk about, what happens if you want to litigate one of these, and then also how to negotiate or draft them. But burden of proof here is really interesting. So I'd like you to close your eyes and kind of envision a tennis match where you have the ball going back and forth. So the ball is in your side of the court, the ball is on the other side of the court. In terms of the burden of proof, the employer must prove that the restraint is reasonably necessary to protect the legitimate business interests. So we have that term coming up again. It has to be something that's necessary to protect their interests. Let me just give an example there. Let's say you're a cardiac group. Let's say that Dr. Smith wants to leave, but Dr. Smith only wants to practice internal medicine. Your cardiac group really does only cardiology. And of course, there's some overlap in terms of when internal medicine becomes cardiology, but you don't have any sort of general patient internal medicine appointments. If the cardiac group enforced the non-compete and said, Dr. Smith can't work, even if she's doing internal medicine within that area, a judge might say, you really don't have a reasonably necessary situation going on here. She's not going to steal your cardiac patients away by practicing internal medicine. So it has to be reasonably necessary. Another situation in which the reasonably necessary comes into play is this. I have a practice on the north side of Jacksonville. The non-compete for my practice includes Clay, Putnam, Duval, St. John's, and Nassau counties. We have no patients from St. Augustine. We have no patients from Hastings. We have no patients from Green Cove Springs, but the non-compete prohibits that. Now, more likely than not, a judge would say, hey, listen, practice, you don't have a legitimate business interest in keeping Dr. Smith from opening up an office in St. Augustine because you don't have any patients from there. So again, you can see how all of this is really fact-intensive, and a statement like, oh, non-competes are not enforceable, is really not that solid of a statement because it really depends on the specific situation. So back to the slide. If the employer establishes a prima facie case, then the employee has the burden of proving that the restraint is not overbroad, overlong, or not reasonably necessary to protect the legitimate business interest. So the ball in the tennis match is first on the side of the employer. Is this reasonable, and is there a legitimate business interest? And if the judge buys that argument, then the judge sort of allows the employee to say, well, Your Honor, that might make sense on paper to have a non-compete that includes Putnam and St. John's counties, but they don't have any clients there or any patients there. So I think this is overbroad, and you have the opportunity then to establish that. So let's talk about time. Interestingly, in the state of Florida, this is regulated by statutes. The actual laws of the state of Florida say that a non-compete is presumed reasonable as to time if it's 6 months or less. Presumed reasonable. That means the judge has no wiggle room as to the element of time if it's 6 months or less. However, the statute goes on to say that it is presumed unreasonable if the duration is for more than 2 years. Now, you can rebut that presumption, but the starting point is that the judge has to either presume it reasonable or unreasonable based on these time frames. So, when drafting a non-compete for an employer, what time frame do you think I usually insert? 2 years. Most employers want to just, walk right up to the line and say, if it's presumed unreasonable, if it's more than 2 years, then let's be in that gray area as close as we can and go ahead and put it 2 years. So almost every non-compete that I draft is a 2-year non-compete. But let's think about that. For all intents and purposes, 1 year is probably enough. And we'll talk more about this in terms of the negotiation, but think about it. Those of you who are practice managers or physicians, if you are prohibited from seeing your patients who have chronic illnesses who come to see you every 6 weeks, if all of a sudden you can't stop, they're going to find and establish themselves with another physician, right? Because they can't wait for you for 6 months and not get treatment. And more often than not, once that relationship is transferred, they usually stay there. Maybe they'll come back to you at the end, but once they get used to going over to the other guy, the fact of the matter is that they kind of usually stay there. So you're going to lose some money not being able to see them. So on a practical basis, 1 year is probably enough for the employer to really kind of capture and retain the patients once the physician leaves. So what typically happens, is the employer will send out a letter and say, Dr. Smith has just left. However, we also have employed here Dr. Jones, and we will be continuing to see you and keep your records here just as if Dr. Smith was still here. So just any interruption in that process from a practical and business and operational standpoint is usually enough to sort of end the patient-physician relationship. Let's move now to area, meaning geographic area. Like my example of the practice on the north side of Jacksonville, an employer has to have a legitimate business interest in the area. So if you're, in the north side of Jacksonville and none of your patients drive all the way up from St. Augustine, you probably can't stop your physician from working and establishing a practice in St. Augustine. From a drafting standpoint, put me in the position of working for the group. Just because it's in writing doesn't mean that a court will enforce it. So I'll ask my clients, well, where do your practice's patients come from? Really, like, what is your real geographic area? And then we might go a little bit farther because, frankly, it doesn't hurt to put in a little bit more from the employer's standpoint. So if you might get maybe 10% of your patients from St. Johns County, let's let the judge decide. Just like the phrase, if you don't ask, you don't get. If you don't put it in there that it's a protected area, you don't have the opportunity to ask a judge to opine as to whether you have a legitimate business interest in that area. So when I'm drafting, I usually go on the side of being a little bit more expansive. What are typical descriptions of the geographic area? It seems more often than not that we see an X mile radius from a point. So by radius, we mean we're putting a pin on a map and we're doing a straight line radius surrounding that site. I have had medical doctor clients come in and say, oh yes, I'm outside of that prohibition, that 10-mile prohibition, and they put a MapQuest map in front of me. And while the route in the road might be, might be compliant with the 10-mile prohibition, that might not be the case if you lay it out in terms of a radius. So be careful there. From a negotiation and fine print standpoint, be very careful about where the pin is in the radius, where the pin is, where the radius is starting from. Is it from any office of the huge health system, or is it from your, quote, primary location? So if I'm representing a group that has practices up and down the coast of Florida, I would recommend that we make it a 15, 20 mile, depending on how far apart they are and where you draw from, radius from any office of the employer in existence at the time of the termination of employment. So you kind of want to be clear as to whether it was at the time you signed the agreement or, at the time that the employment agreement was terminated. So there's a little bit of a time issue there, but you want to be as expansive as possible if you're the group. And on that note, the fact that you sign an agreement in 2016, it might be something that you might have to enforce 5, 10 years from now, depending on how frequently you update your employment agreements. So you might have no idea where you might be expanding to in the next 5 years. So if you did one of the things like you did zip codes or counties, and you have expanded, you would have to amend your employment agreement to make it apply to those new areas, right? We all know what a pain it is to get a little amendment signed by all the physicians employed by the group, but that's what you would have to do. That's why I usually like to go with an X mile radius from any office of the employer at the time of termination of the contract. It allows you to grow and expand without actually specifically listing the locations or getting amendments. Now, let's put the tennis ball on the other side of the court. If I'm representing the physician, I really like to narrow it down and try to have that non-compete be within an X mile radius of their, quote, primary location. So if we're going to put the doctor at 13500 Sutton Park Drive, if that's where my client is going to work, I want it to be within a 20-mile radius of, and I put the specific address in the employment agreement, of 13500 Sutton Park Drive. And I try to keep it that way. That's one of the things that's probably the biggest negotiation area of physicians with big systems. The idea of it is, now we talked about whether it's in writing versus whether it's something that would be enforced. If the physician came over here to the Intercoastal West and worked at 13500 Sutton Park Drive and then wanted to leave, and the non-compete was, let's say, with big health system here in Jacksonville, and it said 10-mile radius from any of their locations. So XYZ health system, XYZ primary care. Let's say they have 40 locations throughout the metropolitan area. If I was representing the physician in front of the judge, I would say, Your Honor, the relationship here is between this physician and his patients. If he goes and establishes an office in Orange Park, he's not going to steal any of those patients away. That non-compete is really not substantially related to the legitimate business interest here. So that doesn't necessarily give my clients a lot of comfort to say, I'm trying to negotiate this for you, but the employer is just not giving. They won't limit it to just your primary location. I say, but the fact of the matter is, I don't think it's enforceable in the long run. Now, I realize that that does not give a whole lot of comfort, but that might be the fact of the matter as it all plays out. Here in Northeast Florida, we will often see prohibitions that say something like, physician will no longer, at the time of termination and for 2 years after, practice rheumatology in Nassau, Duval, Clay, Putnam, and St. Johns counties. Well, that's very, very normal. Same thing in the Orlando area. Same thing, Volusia, Brevard counties. You'll kind of see this kind of county subset, which is really kind of interesting. In more of the general specialties, we sometimes see zip codes. We also sometimes see zip codes when it's a hospital employer and the physician's being recruited into a healthcare practitioner shortage area or an underserved area where the zip codes that are the hospital's primary service area are linked to the subsidy. And I have a slide on that we'll get to later. but sometimes we'll see zip codes. All right, let's turn to a different slide here now, the service line. So what is it that I can't do, Anne? So I was a cardiologist, but I can't go and practice internal medicine. From the broadest standpoint, we will, and perhaps the most vague, we'll sometimes see something that says you can't compete with the employer. Okay. And then my clients often like to make fabulously creative arguments about how, well, that practice primarily does XYZ, and I do XYZ squared, and so it's not really the same, so I don't think I'd be competing. And that's when I use my, well, doctor, can you look your mother in the eye and really make that argument that they are really different? And do you really want to make that argument to the judge? So before you leave and set up shop in the new place, let's talk about that. Is it really competitive? And sometimes the discussions get really in-depth about that. I just saw a question flash up on the screen. Is there an unreasonable geographic area? That's a fantastic question. Thank you for that. And I'm just going to go back. So here on this slide about time, we had, this is in the statute. So it is in the books. It's presumed reasonable if it's 6 months or less. It's presumed unreasonable if it's 2 years, if it's more than 2 years. There is nothing in the statutes like that as to geographic area or as to service line. So in terms of area, it really comes down to whether the employer has a legitimate business interest in the area. And the best way I can really explain that, and the way the courts have explained it, is where are you getting your patients from? So again, if you're on the north side of Jacksonville, you know, do you have any patients who really drive up from St. Augustine? So it's something that a judge would look at, and there is no presumption as to that. So back to service line, same kind of thing. There's no presumption or anything like that. Sometimes we'll see, you know, the physician cannot practice medicine within 10 miles for 2 years. And I'll have a client who will say, well, you know, I'm really not going to practice medicine. I'm going to go be a professor at the University of Florida, and I'm a kind of an administrator, or I'm a medical director. I'm not really practicing medicine. Those are some creative arguments sometimes too. Sometimes we'll see practice within the specialty, and maybe specialty will define, maybe it was sloppy and it wasn't really defined in the contract, but then we get into creative arguments as to what is the specialty. For example, I use the next one, which is really specific, practice anesthesiology. Well, what if it's pain management? Is that within the specialty of anesthesiology? So you can see some of the considerations that your attorney should guide you through as you are drafting the language in terms of the service line or what it is that the physician cannot do. There are some defenses in the Florida statute. These get to sort of the fairness argument. And I highlighted in red number 4. Before I moved to Florida, I had practiced in both Kansas and Missouri, much more rural areas. And the ability for someone in western Kansas to get to a specialty physician is quite difficult. And in those states, they really did have stronger protections, mostly in case law, about whether the effect on public health or safety or welfare was important. Here we do have that if there's an impact on public health, safety, and welfare, they have to consider it. In contrast, though, from the physician standpoint, check out number 1. The court shall not consider any individualized economic or other hardship that might be caused to the physician. So if the physician just bought $1 million home, just moved here 6 months ago, and you know the employer for no reason fired this fantastic physician, and now the physician is going to have to sell his house, transfer his 7 children to a different school, the judge doesn't care. Personally, the human being judge might care, but this statute says that he can't even consider that. So again, to folks who say, oh, non-competes are not enforceable. To the contrary, this statute is really fairly pro-employer. All right, so let's move on to interpretation. When a judge is interpreting a contract, which a non-compete is, there are some sort of soft rules that go along with that in the law. Is there a presumption one way or another? What if it's vague? Do we defer to one side or the other? And this is actually language straight from the statute here on this slide. It says that a court shall construe a restrictive covenant in favor of providing reasonable protection to all legitimate business interests established by the person seeking enforcement. Let's break that down. That means that the court has to interpret the contract in favor of the employer so as to protect any legitimate business interests. This is a very, very pro-employer. Furthermore, there's a provision in contract interpretation rules that generally says that if an employer drafts a contract, it's their contract, they wrote it. So we're going to, if there's anything that's vague or not clear, you know, it's their problem. It's the employer's problem. They should have thought about that at the time and made it a better contract. In non-compete enforcement, a court shall not employ any rule of contract construction that requires a court to construe a restrictive covenant narrowly against the restraint or against the drafter of the contract. So no narrow interpretation, no presumption against the restraint, and no, not against the drafter of the contract. Again, if there is probably no other statute in the state of Florida that is so pro-employer, pro-terms of the contract. I mean, it's really hard for a physician to argue against these sort of rules. It's almost, in a way, like the deck is stacked on the side of the employer. This is what I had talked about earlier in terms of recruitment agreements. I used to hear that you can't have a non-compete in an employment agreement of a recruited physician where the hospital in town is subsidizing that physician to come here. So some of you might not have much familiarity with this, but there's an exception in the Stark Law that allows hospitals to pay physicians just to come to an area and work in a shortage area. And they've actually clarified that now you could still have a non-compete as long as the physician can still work in the hospital service area after he leaves. What goes along with these recruitment agreements is usually a 2 or 3 year commitment to stay after they've funded you and supported you for a while. And so you can limit it in a certain amount in terms of what happens if the physician leaves, but not too much. All right, let's switch gears now to, it's a day in the Bittinger law firm, and the phone call that we get is, Dr. Smith is out there competing. What do we do? All right, what you need to do is get an injunction. That means you got to go downtown to the courthouse. An injunction is kind of like a temporary restraining order. It's where the judge says, hey, you got to stop doing what you're doing. Something similar in family law might be a restriction that somebody can't get close to somebody. Somebody can't get within five miles of somebody, that sort of a thing. So it's an injunction telling you you can't do what you're doing. Typically, you can go in and get a temporary injunction, and then there's a hearing and a permanent injunction is given. So there's a presumption that there's injury in the statute. A bond is required for a temporary injunction. So let me move down to my final bullet point on this slide. In order for an employer to enforce a non-compete, that employer has to hire a lawyer who will put together a case to get an injunction. That's a few $1,000s, no matter how good of an attorney you get. In addition, the employer will have to post a bond. Now, depending on this type of employer, that bond might cost certain amounts, or usually you don't have to put up all of it, but typically the court will ask for about a $5,000 bond. So an employer has to take some steps and spend some money to actually get Dr. Smith to court and then to try and enforce the injunction. So, an employer can't just walk into a judge's office downtown and say, hey, look at this contract. I need you to enforce this non-compete. They have to schedule a hearing for a temporary injunction and bring a check that can be written out for a bond. So it does cost some money. The Florida statute actually says that via contract, you can't waive that bond requirement. I see that in contracts all the time. Physician hereby waives any requirement for the posting of a bond for enforcement of this restriction. That's not enforceable in Florida. Attorney's fees. What does the contract say? So if the contract says that the winning party can have their attorney's fees paid for by the losing party, the judge will uphold that. So from a drafting standpoint, if I'm an employer, I want to make sure that there's an attorney's fees provision in there. The statute in Florida says that in the absence of a contractual provision authorizing an award of attorney's fees, a court may award attorney's fees to the prevailing party. So that's really kind of interesting. It's up to the judge's opinion about whether to do that. But a judge shall not enforce any contractual provision limiting the court's authority under this section. What that means is a judge is not going to not award attorney's fees just because the contract says nobody gets attorney's fees. So if there's an actual proactive language in the contract that says neither party gets attorney's fees, the judge doesn't have to follow that according to Florida law, and they can award attorney's fees. So let's talk about damages. We had just talked about the injunction. An injunction is when a judge tells you to stop doing something. An employer can also get damages. If you act quickly as the employer and you get an injunction right away, arguably you have not very much in damages, right? Because the physician who left didn't actually steal any of your patients away and bill and get paid for that. But one thing some employers do, which is interesting, is go ahead and let that physician compete in violation of the non-compete, and then right at the end of that, 2-year period, file suit and say, you know what, you're in violation of this non-compete. We understand that you've probably seen about 500 patient office visits involving our patients. We're suing you for the value of that, what you made from that. So when I'm representing a physician, that's probably the scariest thing. I mean, sure, you might, rent some space and get tied into a lease and be told that you really can't be there in that area if the employer enforces a non-compete. But what if they wait for like a year and 9 months and then file suit and try and get back everything that you had made for seeing their former patients? That's some scary stuff, and Florida law will definitely support that kind of a judgment if, again, all of the requirements as to line, time, and area that we talked about previously are met. I'd like to turn now to some case law interpretation. It's funny, this series is a little bit more legal and court-heavy than some of the webinars that we do. This one, I actually include a map of the District Courts of Appeals in Florida. So a little Court 101 here. If there's a physician in Duval County that's violating a non-compete, that's going to be heard in Duval Circuit, Duval County Court here downtown in Jacksonville. If one of the parties wanted to appeal that decision, they would appeal that to the first DCA, the First District Court of Appeals. You can see Duval County right there in the top right of the orangish color there. So the First District Court of Appeals, it's one court, one body. They hear all appeals within that geographic area, and they make a decision. Same thing, if it was in St. John's or Daytona, it would be in the 5th district, and Tampa in the 2nd, so on and so forth. So what happens in the law is that sometimes the 1st DCA has very similar set of facts to a case that was heard previously in the 5th DCA, and they came to different conclusions, and we call that a conflict. When there is a conflict between district courts of appeals, it can go up to the Florida Supreme Court. So with that Law School 101 in mind, I want to run through a few cases here. Let's start at the bottom. The 1st District Court of Appeal was actually a University of Florida case, and it's the oldest one on my list. It was the 1st DCA, and it was in 2003. That holding was mostly for the employee. It was pretty much the employee could do what he was doing. The most pro-physician case on this list is in the 5th DCA, which is the Florida Hematology and Oncology. And then we've got the Hines case, an old Supinski case, and then the Infinity case. So let's take a look here at some of this case law. Supinski was really interesting. This was an old one, kind of like the University of Florida one. This was kind of on, we're going to go in terms of a spectrum here. This was kind of like the most blatant sort of violation of a non-compete that was considered by these courts. So there was a blanket non-compete, 10 miles of any of his offices in Brevard County, 10 miles within any of the employer's offices within Brevard. This guy left after working there 6 months, and he opened his own office 4 miles from where he actually worked for the employer. Okay, so he's within violation of the 10-mile non-compete. In his new practice, he saw 40% of the patients that he saw, were former patients of the employer. The holding here was for the employer, and the court, the 5th DCA, upheld an injunction to stop the doctor from working in that area. This was kind of one of the first cases where they really looked at the distinction between whether he's just working in the area or whether he's actually seeing patients from the other employer or from the original employer. And that's an important distinction. So the point of this case was you can compete, but you can't pirate. You know, if you want, and in this case, there was really kind of a question about whether you could even compete within those 10 miles at all. But the idea that you can't pirate the patients, that you can't steal the patients away. Then let's move on here to the Tummala case. About the same time period, but this was up here in the 1st DCA. It prohibited him from treating all individuals who lived in a certain geographic area. And here, the court said that the legitimate business interest must be substantial, and it must be with particular identifiable individuals or patients. So this is where we start getting into the whole, well, is he really pirating patients away? Again, this court kind of said you can compete, but you can't pirate patients. Then we get into the lovely case of Dr. Tummala. I love this case because he just did so much to comply with the law, and he actually won. So Dr. Tummala left Florida Hematology and Oncology in Lake City after he had agreed to a 2-year, 15-mile non-compete as to the practice of medicine. So pretty broad and a pretty decent area in Lake City, right, in terms of 15 miles. So the company terminated him without cause, just let him go, and he opened an office within 15 miles, but, and I quote the opinion, he took extraordinary measures to assure that he did not accept any of the appellant's former patients. So the analysis here was really kind of the first good in-depth opinion about existing patients versus referring physicians and prospective patients. So as to existing patients, you know, the court did uphold that. You know, you can't see any patients that were patients of Florida Hematology and Oncology because those are specific prospective or existing patients, and there's a substantial relationship because the practice treated the patient. Moving on to the referring physicians. This is where the referring physicians really got dicey. So the employer for the group argued that they have fantastic relationships, not economic relationships, but just good relationships with all of the primary care and other specialists in town who would refer potential HEMONC cases to them. The court said that while that might be admittedly problematic, those are not specific prospective patients. They're not going to enforce a non-compete against general prospective patients. So what this means, that sort of the reading between the lines here, is that it's okay to be within the geographic area as long as you don't pirate patients, right? As long as you don't see any of the other patients. So from a legal standpoint, this case took an interesting route. It was a 5th DCA case. The 5th DCA affirmed the trial court. Then the Florida Supreme Court had heard an oral argument, and we were all very excited because we would love to have the Florida Supreme Court say something here and kind of create a law of the land. And they determined that they didn't have jurisdiction on this case, and they dismissed review. But again, the point was, in this case, you can compete, but you can't pirate, okay? So we've had 2 recent cases in 2006, and bear with me, I know this is kind of lawyer heavy. And there's a couple things about these 2 non-compete cases that are the most recent. Neither of these involved physicians. However, they really focus on that element of the referring physicians and the prospective patients. So in Hines versus Americare, the employee who left was a home health agency liaison whose job was specifically to forge relationships with referral sources. Hines had the moxie and sense to email from her work email to her personal email on her very last day of work some interesting information that the company held. The decision doesn't get into too much detail about what it is, but I'm betting it's list of referring physicians and maybe contact numbers from hospitals, hospital discharge people, perhaps. So the 5th DCA reversed. The trial court said this is different than Tummala, and they actually granted the injunction to stop Hines from doing what Hines was doing. Then the DCA reversed and said that Tummala is not distinguishable because there was no evidence that she used the emails to compete with Americare. So she kind of stole the stuff, but she never used what she stole, right? It's an interesting rationale. The 5th DCA said that substantial relationships with specific prospective or existing patients, that standard does not apply to referring physicians, that there's no legitimate business interest in referring physicians. The court said that Americare has no relationship with potential patients, and patients is the word in the statute. You know, the statute, where I pointed out at the beginning of our talk today that it actually said patients, it didn't say referring physicians. It didn't say people who send patients to you. So interesting that they really grasped onto that. And then they actually certified conflict with the 4th DCA for the Infinity case, which was decided within just about a month time frame. In this case, we had a similar situation. It was in Broward, and Sylvie was a care transition coordinator, primarily responsible for developing and maintaining the company's relationships with case managers that would refer to this company for home health. So she signed a non-compete. She left and went to work with the competitor and immediately began soliciting referral sources. And in this case, she was trying to basically steal away the foundation of referrals that they got from the Cleveland Clinic. So what happened here when this was taken to court was a temporary injunction was issued to stop Sylvie, and then it was affirmed by the 4th DCA. So the 4th DCA, so if you're just a few hundred miles south down in Broward, referral sources may be a legitimate interest under the law depending on the facts and circumstances. And so they certified conflict with Tummala. So this is ripe for the Supreme Court of Florida to hear. So to make a long story short, if a client from Duval County comes to me, or a 5th DCA, first is perhaps a little dicey, but 5th DCA, I might say, hey, listen, Tummala is the law of the land in our district. A lower court has to follow this. So if a lower court or a county court, circuit court were to hear this case, they'd have to follow it. So yeah, you can open up shop right across the street, but don't see any of the old practices patients. Now, if a client from Broward County was asking me what to do, my advice would be just the opposite. My advice would be, hey, it's not clear, but you probably don't want to practice within that geographic area, even if you don't pirate or see any of the patients of the old practice. So this is the kind of dicey situation that lawyers have to deal with in Florida right now. The Infinity case basically said you can't pirate and you can't compete. Interesting stuff. So let's turn now to some drafting tips. These are some kind of straight out of my drafting Bible for non-competes. Generally speaking, if I'm representing the employer, I want the language to be as broad as reasonable under the statute, not necessarily as broad as possible, because you don't want to look ridiculous to a judge. You don't want to say you can't work anywhere in the state of Florida. But, I might go ahead and make it in a 5-county area instead of a 2-county area if it's reasonable. If there's an ability to relocate, tie the non-compete into that. So that's kind of a bigger picture. In terms of drafting, if you're like relocating the physician, you're giving them moving expenses, a sign-on bonus, that kind of thing, tie that to the non-compete. There's lots of other things, too, that you can tie to the non-compete. For example, you might allow your physician to leave and to compete, but then he's not going to get his accounts receivable when he leaves. So you can have sort of some liquidated damages provisions in there. Because the last thing you really want to do is be spending your time down at the Duval County Courthouse enforcing this, right? But if you know that, whenever a cardiologist leaves our group, his accounts receivable are usually $250,000 that he usually gets paid out according to his contract, well, then maybe it's easier for us just to keep his accounts receivable, and so on and so forth. You might have him sign a note that says that if he leaves and violates his non-compete, then, he agrees to pay you back something, relocation fees or sign-on bonus or something like that. So you can make the non-compete almost like one ingredient within a cocktail that you're mixing. You can make a whole bunch of different drinks with a whole lot of different ingredients. So sometimes what we'll do is tie the non-compete into some other issues that are even more important to a particular group. In terms of the language, any location at which the employee provides services. I had a non-compete case where a physician left, was opening an office outside of the geographic area as to her primary location. However, this physician had done a few clinics at a satellite hospital of this employer that would have been within the non-compete area. This doctor worked at that satellite location just a few days in 1 year, so very minimal. That contract did not say that it was from any location at which the employee provided services, but if it had, that makes an even wider non-compete. So you might, if you want the broadest kind of language possible, you might say something like within any location that the employer treats patients or at any location in which the employee provided services. Might be one of the same, but maybe not. One thing with non-competes is I usually try to specifically address the issue of medical staff privileges. So let's say we employ a surgeon and we have an office downtown in the Baptist Medical Center office building, and we have a non-compete that's 20 miles from any office location. Okay, you're a surgeon. Your office location really doesn't matter. Does that language cover doing procedures at that hospital? Interesting, specific as to the language. So for hospital-based physician groups, that's even more important. For radiologists, pathologists, anesthesiologists, I usually do a clean sweep in those agreements too, so that at the time of execution of the agreement, the physician agrees to give up his medical staff privileges upon termination of the employment agreement. And it even gives the power of attorney, if we really want to be tough, to the group to go ahead and revoke and resign from the staff altogether if the physician doesn't do it. So those are two different things, hospital medical staff privileges versus employment. So keep that in mind. I usually like to be very broad in terms of the definition of the services. And I wanted to point out something that I'm seeing more and more often as we have greater consolidation in healthcare. It seems like the health systems now are more than happy to employ you for a few years and have you leave if it doesn't work out, and have you stay, maybe even in the same office location, as long as you still send all your ancillary services to the hospital. Now, nobody's saying that, right? Nobody wants to talk about the R-word referrals. But what I'm seeing in terms of non-competes now that the systems are doing is you can't work within 10 miles for 2 years, or it might say that you can go and work, however, you cannot work for a competing health system that operates a hospital. So just to use two big players, hypothetically, in Jacksonville, the Baptist employment agreement could say you can leave. Typically, they'll make it like a proactive thing. So I can't say that this is what Baptist says, but generally we'll say something broad like you can't work within 10 miles for 2 years, provided, however, that you can go and work in an independent physician-owned group as long as that group is not employed by a system that owns a hospital. So they don't want you to go and switch gears and go work for UF or St. Vincent's, okay? And that was just a hypothetical, but that's what we're seeing a lot of right now. So the big systems are carving out their competitors. Negotiating tips for the physician. For most physicians, the main issue is the whole geographic thing. The timing is one thing. If you're a physician and you're unhappy with your employer and you're going to leave, most physicians really can't take a sabbatical for 6 months. I've had one or two that have done that, and I get awesome Facebook posts from them, all around the globe. But that's not really a reality for a lot of physicians. They need to go and set up shop somewhere, and they don't want to have a 2-hour commute every day. So the biggest thing that you could do is really kind of try and negotiate where that primary location is from the pin with the radius, okay? So it extends from one area, not from 17 different offices, and not from zip codes or counties, okay? Another way I like to mix the cocktail in terms of negotiation of non-competes is, well, when does the non-compete apply and when does it not apply? And we can apply that as to reasons for termination, whether it was for cause or without cause, or whether there was a time frame for the termination. Let's start with that one. I might argue that if the physician leaves within 2 years, maybe the non-compete shouldn't apply because the employer already got back all of his investment that it took to train this physician and bring him up to speed. So the non-compete should just go away once they've been there 2 years. I've actually heard that argument being made. The flip side of that is, just the opposite. After the physician has been there, employed with the group for that long, he's got a heck of a lot more patients that he could steal away. He's got more relationships with referring physicians. So it should definitely apply after 2 years. But you know what? Maybe it shouldn't apply before that. So we might try and negotiate that. Should a non-compete apply if you've got a resident who just, it's his first job out of residency, he moves down here from Kentucky, buys a house, and you decide to let him go without cause within the first year? I might try and negotiate, if I'm representing the physician, to say that, you know, the non-compete doesn't apply unless he's terminated for cause after a certain time period. You know, from a physician standpoint, if you're the one who's triggering the termination, then it's, you know, probably more reasonable for them to enforce it. But the ability for an employer to let a physician go at any time with notice, I suppose, but without cause, and then require a non-compete can really just have the effect of an immediate for sale sign in that physician's house and forcing him to move and be without an income for quite some time. So to try and even out that playing field is something I usually try and do for physicians. How often do I see non-competes in employment agreements? You know, almost all the time. Almost all the time when I look at an employment agreement, is there a non-compete? And keep in mind that non-competes often don't stand alone, because one of the Contract 101 requirements for a contract is there has to be consideration. Somebody has to give something in exchange for something else, offer, acceptance, consideration. So if you're just signing a non-compete and you're not getting anything like a job and benefits and that kind of thing, according to this contract that's, you know, standing alone, there's some questions about whether that would be enforceable. So usually we tie them into the actual employment agreement. If you have a current contract and you've been listening for the last 55 minutes and say, man, our non-competes are really subpar, keep in mind that to enforce a non-compete, both parties have to agree to it in writing. If you're amending in a contract to add a non-compete, both parties have to agree to it in writing. So here's the situation. We have 40 doctors. We're going to update our employment agreements and we're going to add a non-compete to it. What happens if the doctors refuse to sign? Well, then you're in, you know, back from where I come from in Abilene, Kansas, and there's a showdown. Somebody's going to have to pull the trigger. So you either have to give them notice that they're without a job, or, you know, they're going to continue under their current agreement. To make a long story short, what usually happens there is power of politic within the group, and maybe giving them some benefits in some ways that they wanted to secure, so put some pro-physician things in there in addition to the non-compete to make it more fair. So I'll leave you with this. If you haven't done housekeeping as to employment agreements in the last 5 or 7 years, you probably need to. Most of my clients' businesses change so much that within 5 to 7 years, it makes sense. You know, whether there are new locations, physicians who were not senior physicians are now senior physicians, the tone changes, we have older docs in proportion to younger docs at greater numbers. Those kind of things happen, usually within about a 5 to 7 year time frame. So other things that are impacted by those kind of changes are insurance, indemnification, EMRs and health information. I'm seeing a lot of folks that are scared about Medicare takebacks and penalties and False Claims Act, and they're adding provisions in their employment agreements that if a physician is intentionally doing things wrong in terms of his coding and overbilling, that he agrees to pay the group for anything the group has to pay back to Medicare. Those kind of things are nice to keep up to speed on. And then, of course, we're in a changing world of compensation structure for physicians right now, for certain, in terms of RVUs, productivity, incentive, medical homes. So, you know, every 5 to 7 years, regardless of what your non-compete looks like, it's probably a good idea to go through a process with your attorney to update your employment agreement. So with that, I leave you. I thank you for attending. If you have any questions, there's my email address and my phone number, and I look forward to hearing from you. Thank you very much.